when I made those decisions, I, of course, was presiding over a detention hearing. That's one of my responsibilities as a magistrate judge. I considered the factors under the Bail Reform Act, which, of course, is the governing statute in detention hearings, and I found that there were that there were conditions of release that would reasonably assure the safety of the community and the defendant's appearance at trial. And then the district court judges disagreed with me on that, sir.
When we look for a fundamental right in the Constitution, and we know from Supreme Court precedent that you and I have fundamental rights according to Supreme Court precedent, we have fundamental rights that are not expressly delineated in the Constitution. One example is the right to privacy that we just talked about. What is the Supreme Court standard for looking?
Question in this area. Do you agree with student advocates that certain categories of clients, quote unquote, don't deserve civil representation?
I'm sorry, Senator, I don't know. I'm not familiar with the organization or the quote.
Okay, then why don't you answer that in writing for me?
What if I told you that the person who tried to assassinate a Supreme Court justice just got 8 years in prison instead of 30? Yeah, you heard that right. A Biden-appointed federal judge just handed down what critics are calling one of the most lenient sentences in modern judicial history. Let's break down what happened, why this sentence has America divided, and what this could mean for the integrity of the courts. Before we dive in, if you care about justice, accountability, and the truth behind headlines the mainstream media won't touch, hit that subscribe button and turn on the bell so you never miss an update. In 2022, police arrested Sophie Roska, formerly known as Nicholas J. Ross, outside the Maryland home of Supreme Court Justice Brett Kavanaugh. Roska was reportedly armed, confessed to planning an assassination, and told authorities he was motivated by political outrage over recent court rulings. The Department of Justice pushed for a 30-year sentence, calling it a direct threat to the independence of the Supreme Court. But last Friday, Judge Deborah Boardman, a Biden appointee, sentenced Rosk to just over 8 years in prison. The reaction? Explosive. Across social media, conservatives and legal analysts slammed the decision as shockingly lenient. Many accuse the current administration's judiciary of going soft on political violence, especially when the targets are conservative justices or public figures. Former Attorney General Pam Bondi called the ruling woefully insufficient and vowed to appeal the decision, saying it sends a dangerous message that violence against ideological opponents won't be punished seriously. So why only 8 years? Judge Boardman said she weighed mitigating factors, including Rosk's immediate confession and cooperation with law enforcement when making her decision. But critics argue that leniency like this undermines public faith in the justice system and emboldens politically motivated violence. And it's not the first time Boardman's name has raised eyebrows. Since her appointment by President Joe Biden, Judge Boardman's judicial record has faced increasing scrutiny. During her Senate confirmation hearing, Senator Chuck Grassley and Senator John Kennedy pressed her hard on her independence and constitutional understanding. Grassley questioned her on her past as a federal defender and her decisions releasing inmates that were later overturned. Kennedy grilled her on basic constitutional principles, like the rational basis test and penumbras, and she struggled to define them clearly. Those moments, now circulating online, have reignited debate about whether she was truly prepared for the federal bench. Now, with this sentence making national headlines, many are asking, is America's justice system becoming politically biased? Would this same judge have shown leniency if the target had been a liberal justice or politician? It's a question echoing through Congress, the courts, and homes across the country. And as the appeal moves forward, this case is quickly becoming a flashpoint for judicial accountability and equal application of the law. At the end of the day, this isn't just about one judge or one sentence. It's about what message our justice system sends, and whether it applies the law the same way to everyone, no matter their politics or identity. Do you think 8 years is justice served or justice denied? Drop your thoughts in the comments below. I read every one of them. And don't forget, if you believe in holding our leaders and courts accountable, hit that subscribe button, tap the bell, and join this growing community that
Judge
stands for
Boardman,
truth,
apart from
balance,
being a
and
federal
justice.
defender, you spent some time as a top associate working pro bono matters at a major law firm. First question, do you think law firms should allow their paying clients to influence which pro bono clients they take? And you can give a short answer if you want to.
Thank you, Senator Grassley. I did have extensive experience at a law firm doing pro bono work, and it was an extraordinary experience as a young attorney. To answer your question, no, I do not think that paying clients should have any influence on which pro bono clients that law firms decide to represent.
Next, should law firms undertake the pro bono prosecution of crimes? If so, which crimes?
Thank you, Ranking Member Grassley, for that question. In my experience, at the firm, we certainly did not take on the role of being a prosecutor in crime, so I don't have any experience with that. I would think that is probably best left to experienced prosecutors. Good, I'd be happy to do so.
My second question, you have spent much of your career defending criminals from around the Baltimore area. Many of these cases involve defendants who were charged with unlawfully possessing firearms. Do you think Baltimore would be a safer place if fewer felons and criminals unlawfully possess firearms?
Thank you, Ranking Member Grassley, for that question. Certainly, gun violence is a very serious problem in the city of Baltimore. It's one that I can tell you, based on my experience, both as a magistrate judge and as a federal defender, that the United States Attorney's Office for the District of Maryland is laser focused on combating violent crime in Baltimore. My role, of course, in the process before I became a judge was to uphold the Sixth Amendment and defend poor people who were charged with crimes. And that, of course, did include the people charged with gun crimes in Baltimore.
Over this past year, COVID in prison has been a problem. Courts have needed to strike a balance that keeps prisoners safe and protects communities from dangerous criminals. You have some cases that concern me in this area, and I'd want to ask you about two, Gallagher and Spencer. So I'll only be able to go to one point I want to make. You released the prisoners in both of these cases, but the district court reversed you. Can you talk about what facts the district court relied on in reversing your decision? Then I'll submit the rest for answer in writing.
Okay, very good. Thank you, Senator Grassley, for that question.
Question in this area. Do you agree with student advocates that certain categories of clients, quote unquote, don't deserve civil representation?
I'm sorry, Senator, I don't know. I'm not familiar with the organization or the quote.
Okay, then why don't you answer that in writing for me?
Judge Boardman, tell me what the rational basis test is.
Thank you, Senator Kennedy, for that question. I understand that is probably the first level of review in a constitutional question, and certainly if that matter were before me in a constitutional matter, I would research the law, including Supreme Court precedent, binding Fourth Circuit precedent, and I would apply it where applicable.
What is it? Can you define the test for me?
I cannot, sitting here right now, sir. Whenever I'm faced with any new legal issue, I do the research and I find the answers through research in the case law.
Okay, so you don't know? Okay. What's a penumbra?
Thank you, Senator. My understanding of a penumbra are those rights recognized in the Constitution that are not specifically enumerated.
Okay. We know that privacy is a penumbra, do we not?
That's my understanding, Senator.
Are there any other Supreme Court holdings defining other penumbras?
Senator, I'm sure that there are.
Could you help me there?
I understand there's a right to travel that is not specifically enumerated in the Constitution.
Yes, ma'am. Anything else?
Again, I am sure there are, and I'm happy
That's okay.
to.
Let me ask you one last question.
When I made those decisions, I, of course, was presiding over a detention hearing. That's one of my responsibilities as a magistrate judge. I considered the factors under the Bail Reform Act, which, of course, is the governing statute in detention hearings, And I found that there were that there were conditions of release that would reasonably assure the safety of the community and the defendant's appearance at trial. And then the district court judges disagreed with me on that, sir.
When we look for a fundamental right in the Constitution, and we know from Supreme Court precedent that you and I have fundamental rights according to Supreme Court precedent, we have fundamental rights that are not expressly delineated in the Constitution. One example is the right to privacy that we just talked about. What is the Supreme Court standard for looking at the Constitution and saying, even though it's not expressly delineated, we think that Americans under our Constitution have this fundamental right?
Thank you, Senator Kennedy, for that question. It's hard for me to answer that in the abstract. What I do in every case when I'm presented with a question like that is I research the law and I find Supreme Court precedent on it. So in order to answer that question, I would need to do research to tell you what the standard is.
Well, let me ask, I'm not asking the direct answer. I probably didn't ask that very artfully. I'm trying to understand your appreciation of the state of law. Let's suppose I litigate a case and I say I have a fundamental right to education. And my case reaches the United States Supreme Court. Now, I think we can both agree that the Constitution does not say expressly that I have a fundamental right to education for me, or let's say for my children. Let's suppose I'm arguing that it is implied in the Constitution. What test is the Supreme Court going to use to try to determine whether I or my children have a fundamental right to education, if I argue that it's an implied right, a penumbra, if you will?
Thank you, Senator. Certainly, it's very difficult for me as a sitting magistrate judge to speculate what the Supreme Court would do. But based on my reading of Supreme Court opinions, certainly the Supreme Court looks to the Constitution, the Bill of Rights, the 14th Amendment, the Due Process Clause of the 14th Amendment.
Okay. On an issue like that, a right that's not expressly stated in the Constitution, but it's very important, obviously. We know that absence of education is the root of a lot of our social problems in America. Which branch of government do you think is better suited to make that decision? The decision being whether I have a fundamental right to education. The legislative branch or the judicial branch?
Thank you, Senator, for that question. Certainly the role of the judiciary is to interpret the laws that Congress passes and the Constitution. Mm-hmm. To the extent that interpretation leads the Supreme Court to find a right to education, then that is within their province. Certainly the legislature passes laws to fund schools and to govern education. So each body has its own role.
But what I'm asking is, between the two branches, which branch, in your judgment, is better equipped to decide whether Americans have a fundamental right to education?
I think when it comes to interpreting the Constitution, that is within the province of the Supreme Court, and to the extent that there is a fundamental right to education that's recognized by the Supreme Court, that would be the law of the land.